Before we get started, I want to introduce myself and the other members of the DRM White Collar team. My name is Tim Doherty. I'm an attorney here at DRM in the litigation group and White Collar group. Before I started here at DRM, I worked for the United States Department of Justice as a federal prosecutor in the U.S. Attorney's Office here in Vermont for 10 years, where I devoted much of my attention to business crimes and related matters. I'm going to introduce my teammates as they appear to me on my Zoom screen. So to my immediate right is my partner, Tris Coffin. Tris, before joining Downs, Rachlin & Martin, among his many professional accomplishments, was the United States Attorney for the District of Vermont from 2009 to 2014. He was appointed to that position by President Barack Obama. He is also the founder and chair of Downs, Rachlin & Martin's White Collar Group. It is his brainchild to create and foster an interdisciplinary white collar criminal defense and government enforcement practice group here at DRM. And it was my pleasure to work with him for the 6 years when he was the U.S. Attorney. To Tris's immediate right is my partner, Jen Mcdonald. Jen is also in the litigation group and White Collar group. She has deep trial and appellate experience in both federal and state court systems. And among her many areas of expertise, Jen has tremendous experience in navigating commercial disputes and brings a great deal of practical experience and wisdom to the inner workings of corporations, both here in Vermont and elsewhere. To Jen's right, again, at least on my screen, is the newest addition among this panel to DRM's White Collar Group, Matt Woodbury. Matt joined DRM in the summer of 2020. And in addition to being in the White Collar Group, he is a practitioner in our tax law department. And as an expert in tax law, Matt brings invaluable expertise when our clients face sensitive audit investigations and IRS and state tax investigations. So we're very excited to have you here. I'm excited to present with my wonderful group of colleagues who you're going to be hearing a lot from in the next hour or so. We will leave 5 to 10 minutes for questions at the end, so please submit those or chime in. Our moderator, Jolie Frechette, is helping us coordinate the technical aspects of this, and we're very, very grateful to her for that. A few words about our White Collar Enforcement Group here at DRM. Collectively and with the other members of our group, we represent professionals, executives, business owners, and businesses themselves, in what could be easily described as sort of high stakes, bet the organization type disputes and issues. These include traditional white collar enforcement actions that begin with either a subpoena, civil investigative demand, or in some cases, a charging instrument. But they're not limited to that. And we also represent entities and individuals in response to Consumer Protection Act actions, antitrust matters, environmental enforcement actions, False Claims Act actions, which Tris is going to talk a lot about, and related types of issues and investigations. We also have a very significant prophylactic part of our practice in which we help corporations assess their risks and mitigate their risks before there's an investigation or an action against them. A key component of our prophylactic practice is the internal investigation, which Jen will discuss toward the end of our presentation. The pros and the cons and the benefits and the drawbacks of conducting internal investigations. Our strength, in my humble opinion, and of course I'm a biased observer, but our strength here in the White Collar Group at DRM is that we bring a diverse array of expertise to our clients' issues and bring a multidisciplinary approach to addressing and solving those issues in a creative, prophylactic, forward-looking way. It is the strength of our collective expertise that we think really adds value when our clients are facing these most sensitive and significant issues or potential issues. We thought this webinar was timely because we are approximately a little bit less than a year into the Biden administration. With any new presidential administration, there come significant changes, and this new administration is no different. Most experts and ourselves believe that white-collar enforcement actions are going to increase significantly under the Biden administration. Those types of actions were down considerably in the 4 years of the Trump administration, and we think that they are going to increase, and indeed we're seeing them increase. We're seeing greater devotion to specific types of white-collar enforcement areas from both the Department of Justice under Merrick Garland, from the individual U.S. attorneys' offices across the country as the new presidential appointees begin to filter in, take their place, and set their priorities, and of course across all of the pertinent and relevant federal agencies. So we're going to see, we have been seeing, and we believe we're going to continue to see a more vigorous and energetic approach to these issues from the United States Department of Justice and from the government as a whole. And we thought we would take this time as we approach the holidays and the end of the year to talk to you about some of the most significant trends that we've seen in the last 10 or 11 months, what we expect to continue with respect to those trends, so that you, as business owners, as members of the business community, as folks who are constantly assessing your own risks and your own plans going forward, have the best and freshest information about what's going on in our world. For today's presentation, we're highlighting a couple of things that we've seen that we think are most pertinent for you. The first is what we have seen and what we anticipate to see in the next few years with respect to increased audit activity and enforcement actions by the IRS, and Matt will speak about that. We also have seen and expect to continue to see an invigorated and focused attention by DOJ and the pertinent component agencies on the issue of PPP fraud and abuse. And I'm going to talk for a few minutes about what we've seen on that and what we expect to see on that going forward. Relatedly, we have seen and expect to see invigorated enforcement actions around the False Claims Act and related statutes. And that is something definitely that we see percolating and moving forward. And Tris is going to talk at some length about that trend and what that means for you and for your businesses. And finally, we're going to talk to you a little bit about the value of an internal investigation in response, if necessary, to this climate and things that might be going on in your business, and some of the lessons that we've learned over the last few years as a group conducting those internal investigations. And Jen is going to talk about those issues. So that's the introduction. And without any further ado, I would like to turn this over to my colleague, Matt Woodbury, who's going to talk about everyone's favorite federal agency, the IRS, and what they're up to, and what we expect and perhaps fear that they're going to be up to in coming months. Matt?
Thanks, Tim. I think they've had me go first so that you don't fall asleep with tax talk at the end of the talk. Let me just start my slideshow. And then why are there so many open? Can everybody see that? Okay, great. Everybody can see this? Okay, good. So I'm going to be talking about the sort of short-term outlook for high net worth individuals and the businesses that they own from a tax perspective. And generally, we think that we're going to be seeing higher taxes and increased audit rates. So there, as I said, are two short-term risks to these taxpayers, mostly from the Build Back Better Act on the legislative front, which could result in higher taxes, and then IRS audit initiatives connected to the BBBA, but also independent of that. So the Build Back Better Act is a reworking of Biden's American Families Plan. It's been significantly changed, however, over the last 8 months of intense negotiations and daily changes. It did was whittled down to just about $2 trillion, but the idea is to invest in childcare, climate change initiatives, housing, etc. And it would be funded through increased taxes and tax compliance measures. It narrowly passed the House this morning, so its prospects maybe have increased somewhat, though, as we all know, the negotiations have mostly been going on in the Senate, where it's not clear that they can get the votes they need as the bill currently is formulated. So the revenue raising proposals include increases in taxes for high net worth individuals and entities, business entities. Biden has said that nobody earning less than $400,000 will pay any more in taxes, though that is somewhat disputed. So the proposals really focus on corporations and also high net worth taxpayers. And in addition, and this is sort of a focus on high net worth taxpayers from a different angle, there would be increased funding for the IRS for audits of high income taxpayers. So the corporate proposals, at least as the proposals were formulated recently, they may have changed overnight somewhat, but I haven't had a chance to look at the bill as passed. But there would be a corporate minimum tax, a surcharge on stock buybacks, and then some international reform. For individuals, the proposals have included a surcharge on the very top of the high earner pool in the United States, closing of certain Medicare tax loopholes, and then limitations on business losses. There's also a significant amount of funding that would be earmarked for the IRS. And the idea there is to close the tax gap, which is estimated at $600 billion annually. So it's a huge percentage of the US tax receipts that, at least according to analyses, is not being connected because of underreporting. The focus here would be on taxpayers making over $400,000. And in conjunction with that, there would be increased audits also on entities owned by these individuals, especially pass-through entities, partnerships, but also trusts and private foundations. The Biden administration has estimated that this would raise $400 billion over 10 years. So not a significant chunk of the total tax gap, but a significant amount of funding for the bill, though the Congressional Budget Office disputes this number, and that's also a sticking point for negotiations. The money coming from the Build Back Better Act would be used mainly to reinvigorate or give new life to already existing enforcement initiatives. And in fact, the decline in audits at the IRS has a long history. It's been happening for over a decade and has only been increasing in the last 2 years. In fact, it was at the end of the Trump administration that the IRS started many of the initiatives that are currently being pursued. They've already hired many new auditors and have been investing in technology for automated audits of tax returns. They have a group that people refer to as the Wealth Squad. This is not a term that the IRS itself uses, but that began roughly in March of 2020. And they've already initiated hundreds of audits that otherwise would not have taken place of high-income individuals. They've also been focusing on partnerships, S corporations, and private foundations, as I noted before. And they've been using data analytics, artificial intelligence, and machine learning to increase the efficacy of these initiatives. One of the programs is the Large Partnership Compliance Program, which is part of the Large Business and International group at the IRS. They focus on entities that have receipts in the tens of millions of dollars. Their 2022 focus guide, published a month or two ago, talks about their continuing plans to focus on pass-through entities. There's also an internal memorandum that we have been able to see, which talks in detail about the artificial intelligence initiatives that the IRS is using. More and more e-filing is required, and the data that's being sent to the IRS through the e-filing system is very easy to funnel into computer analysis systems, and so that's what's happening. All returns that are e-filed are being reviewed by AI systems. And agents, when issues are flagged, are required to review the issues identified by the classification software and to make a determination about it. There's also a global high wealth program at the IRS, which is trying to take a more comprehensive view of how people own and make money. So in conjunction with this, there's a focus on hard to monitor and hard to value asset classes. We can expect that the IRS, in trying to form such a picture, will require voluminous information, and that they'll be making requests that could possibly be onerous. So Tim mentioned internal investigations, and similar procedures can be used and are advisable for companies and individuals on the tax front. The an internal self-audit. So this mainly entails looking at returns that are still under the statute of limitations, which is generally 3 years, though it can be extended to 6 years in some circumstances, and to see whether any positions that were taken were perhaps too risky given the current increased audit risk. And it would be much more useful to undergo such a self-audit with the help of experienced accountants and attorneys. The audit risks include back taxes, interest, penalties, and in some cases, civil or criminal actions. And if there is a high risk, it can often be better to approach the IRS on your own initiative to file an amended return, because once an audit has been started, that is no longer possible. The IRS does not view with leniency sort of voluntary compliance after audits have been started. Well, that's all I have for today. So thanks for your attention, and feel free to contact me with any questions. And now I'm going to turn it back to Tim.
Thanks, Matt. Like we said, we'll have time for questions at the end. You know, my take home on this particular subject is that, you know, to the extent that we have more horsepower at IRS and an increased mandate, they're hiring auditors, they're hiring agents, and they're pushing them out into the field. We are going to see more scrutiny at all levels. And I think, you know, the issue of self-auditing, assessing risks, and taking a look at your position in a sort of prophylactic way makes a lot of sense as we enter into this period of transition. And I think it's going to be a new world in terms of IRS enforcement activity. It has been an anemic area, as Matt has said, for quite a long time with the government, and that the winds are changing on that front. In terms of the winds changing, that's a nice transition to PPP and PPP related enforcement actions. Of course, I'm sure that everyone in the business community is well aware, if not intimately familiar, with the PPP activity that has gone on since we've entered into this terrible pandemic. And really, it is the sort of, I want to say, elephant in the room when it comes to what's next in terms of white-collar enforcement by the United States Department of Justice. Just by way of brief overview, the CARES Act was enacted in March of 2020, right as we entered into the heart of the worst phase, or the worst of the beginning of the pandemic. A principal part of the CARES Act was the Paycheck Protection Plan, PPP, which authorized hundreds of billions of dollars in potentially forgivable loans to be made to small businesses through private lenders, but in conjunction with the SBA, the Small Business Association, and all backed by the federal government. The amount of money at stake and that went out the door in such a short period of time pursuant to PPP is just staggering. In the first tranche of applications that ended in August of 2020, 5.2 million loans were made, totaling approximately $525 billion. That is between March and August of 2020, $525 billion. The second tranche, which ended in December, added additional several $100 billion, all of which went out the door, all of which was done under extraordinarily quick circumstances with guidance that was sometimes far from a model of clarity. We've entered into sort of a new phase in PPP world. At this point, applications for loan forgiveness are percolating through, and that has an impact on enforcement as well, which I'll talk about in a minute. It should come as no surprise to anyone, and one does not have to be a white-collar criminal defense attorney to predict that in light of the speed of this rollout and the amount of dollars in play, the Department of Justice is going to and is making it a priority to scrutinize the propriety of these loans, to scrutinize the propriety of these loan applications, and to scrutinize the propriety of these forgiveness applications. And indeed, it has and is making that a priority because, of course, good faith mistakes were made in these applications, but there was also inevitably fraud and abuse, and the Department of Justice is looking into it. So what does that really mean? What does that enforcement look like? Well, a couple things to take note of. You know, the first phase, I would say, of enforcement took place from what we call Main Justice, the Department of Justice in Washington. They have a dedicated criminal fraud unit, and many of the prosecutions in the early phases of PPP enforcement came out of the criminal fraud unit. As of August, so a little bit dated information, but the most recent that I could find anyway from DOJ, as of August of this year, August of 2021, the Criminal Fraud Division in DC with the Department of Justice had prosecuted over 70 cases of PPP related fraud, over 100 defendants, and they'd seized more than $65 million in assets. So quite a bit of work, quite a bit of activity, and quite a bit of success, at least from their perspective, coming out of Main Justice. What we've seen here at DRM's White Collar Group more recently is that the effort to enforce the provisions of PPP and to investigate the propriety of PPP loans has started to be pushed out from Main Justice to the individual U.S. attorneys' offices across the country. Most, if not all, U.S. attorneys' offices now have a specially designated prosecutor called a PPP loan fraud coordinator, who's charged with working on these types of matters and coordinating enforcement actions in these types of matters in his or her particular district. There have also been more centralized, dedicated resources. There's a new position, a relatively new position this year called the Special Inspector for Pandemic Recovery, which is located in the Treasury Department. And there's a Pandemic Response Accountability Committee, which consists of all of the Inspector Generals from the pertinent government agencies that touch upon PPP. So we're seeing both local in the U.S. Attorney's Office enforcement and scrutiny, and we're seeing both also an increased efficiency and increased resources dedicated toward that in DC as well. Thus far, what do we see in trends in terms of enforcement? I would say that what we've noticed in terms of cases that are being prosecuted on the criminal side, it appears to be mostly in the relatively low-hanging fruit type of activity. That's the early successes that DOJ has had. So people creating phony businesses, people creating phony loan calculations, phony assets, phony employees, in order to obtain under fraudulent pretenses these loans. I think we will see an increased level in the sophistication of the investigations and the sophistication in the types of activity that DOJ is looking at as we move deeper into the loan forgiveness phase. The types of charges we're seeing are the traditional white collar charges, false statements to a bank, wire fraud, and the like. But notably, we're not just seeing enforcement in the criminal realm. We are also seeing civil enforcement through the False Claims Act and the Financial Institutions Reform, Recovery and Enforcement Act, both of which, and Tris is going to talk more about the False Claims Act in a minute, and I do not want to steal his thunder, but both of which are civil enforcement mechanisms by which the federal government can recover from corporations and individuals money that was paid out to those individuals on the basis of a false claim. So if there are inaccuracies in the, for example, number of employees that you submitted in support of your PPP loan application, that can result, depending upon the circumstances, in either a criminal investigation or enforcement action or a civil enforcement action. The benefits to the government pursuing these cases civilly as opposed to criminally is that they do not have to prove beyond a reasonable doubt that the conduct occurred. Instead, it is a preponderance, a much lesser standard of proof. But the consequences of an investigation for a company can be devastating and do not just include the refusal to repay the loan, but can result in significant civil damages, not to mention the disruption that comes with responding to a government inquiry of that kind. So where do we go from here, and where should businesses in Vermont and in northern New England, what should they be thinking about with respect to if they have been involved in applying for PPP loans? You know, it is not too late to really vigorously look into the type of application that you made and give it thought and consult again with counsel, and if necessary, take some prophylactic approaches to shoring up the basis from a legal perspective of your claims, and at least having a good sense as to what you're looking at in terms of risk and liability, because we are confident that these loans are going to receive a great deal of scrutiny. Because the False Claims Act is such a key part of that that equation and a number of other equations, it seems like a good time for me to pass the baton to Tris, who's going to talk about what he sees coming forward in False Claims Act work. Tris.
Great, thanks, Tim. And good afternoon, everybody. It's a pleasure to be here with you, and thank you so much for joining us today. I'm mindful of some of the comments Tim made of the aphorism of the famous senator, a billion here, a billion there, and pretty soon you're talking about real money. And I think it's inevitable that with the significant funding programs that are coming through, many for very valuable purposes, there's going to be significant follow-up to make sure that those funds are being used appropriately, and to make sure money that isn't being used appropriately goes back to the taxpayer. The False Claims Act is the government's primary mechanism to recover money for federal programs that, in their view, has been ill spent. Jolie sent me a funny article today about a family in California. The couple had gotten a large PPP loan, and they promptly fled the country with the loan, leaving a goodbye note to their 3 children. While that was amusing and is an example of some of the extreme kind of situations that will probably warrant significant criminal enforcement, the difficulty for most companies and individuals who engage in these federal programs is it's not always so clear cut, and the penalties are severe, and the government plays for keeps and has a lot of chits on the table. Jolie, if you could go to the first slide, please. So, this is really my fundamental point I would like people to take away, is that the False Claims Act is an incredibly powerful tool. It gives the government a ton of leverage against companies and individuals who may be involving in government contracting. And I certainly don't mean to be alarmist or scare people away from that, but it is a fact of life. And it's worth ticking off a few reasons to think about why that is. And don't worry, at the end, I'm going to have a little bit of a prescription, which will segue into Jen's discussion a little bit too, about some things you can do to mitigate that risk. So first of all, fundamentally, the False Claims Act is used to collect fraudulent, but also false claims for payment from federal programs. And that can range from anything for payment for military defense contracting, to COVID response programs, to the PPP loans, to various claims for healthcare payment made by institutions against the Medicare or Medicaid programs. The key thing here is the penalty provisions are very significant, and they can really add up in a hurry. So basically, every claim for payment is subject to $11,000 to $20,000 per claim. Plus, there's triple damages for the amount of each claim. And what's a claim for payment? That really varies depending on the circumstances. A claim for payment for a $40 lab test could expose a lab to $11,000 to $20,000 per claim, and maybe that lab does 500 of these every couple days. That gets big in a hurry. Or the claim for payment could be less periodic, but still with the triple damages figure could be really debilitating. So like if it's a big PPP loan, or payment for a $10 million jet aircraft engine, or it could be something in the middle, like this is a fan blade from a jet aircraft engine. Maybe the contractor is selling those in lots of 200 to the government, and they turn those out, by the hundreds of lots over a period of a year or so. So it really can vary. But the key thing to understand is the government comes with some significant levers in terms of financial risks that can impose on a company in a hurry for kind of what feels as the company's going through the process, a little bit of innocuous kind of behavior. And this is the False Claims Act is also bolstered by the fact that there's something called the Qui-Tam Provision. A lot of people think it's qui or key. My third grade French would say it was key, but my Latin experts tell me it's supposed to be Qui-Tam. In any event, this is the Whistleblower Provision. What that is someone who has knowledge of alleged fraud can file a lawsuit on behalf of the government. They serve it in a secret fashion under seal with the government, and the government gets an opportunity to investigate in the suit, and if they think it has merit, to jump on board and drive that suit. In addition, the whistleblower can recover attorney's fees. Our firm does a lot of different kinds of False Claims Act work. All sorts of, a lot of healthcare fraud, a lot of individual contractor fraud, some defense contracting fraud, individual cases representing just flat out individuals, all sorts of things that involve federal contracting. We're one of a relatively small group of firms that actually do whistleblower, Qui-Tam relator side cases and investigations, and defend companies who are subject to these. So, I think from those, like Tim mentioned earlier, one of the strengths of our firm's group that I love our current lineup here. I just think it's amazing because we've got a lot of different areas of expertise. Jen has a lot of work and experience in the healthcare area. Matt has got great experience on the tax side of things. Tim and I worked together at the U.S. Attorney's Office for many years, and I was very pleased when he decided to come over and join us with his talents to look at kind of complex investigations that we're doing over here. So knowing these enforcement agencies and kind of how they do business, both from working there and also from lengthy legal experience, gives us some ideas on kind of how to manage a case and guide clients, I think, in a way that people who have not quite sort of had the sometimes hard walk in our moccasins have the advantage of using. Let's go to the next slide, please. So it's a really powerful tool, and exposes you to significant penalties, not to scare you more, but, it isn't the kind of fraud statute as well, the False Claims Act, where, there's proof beyond a reasonable doubt. As Tim mentioned, it's preponderance of the evidence, more likely than not, and it requires claims that to be false. And that's a really different kind of a concept in these situations than it is in other areas of the law. False means, untrue, which is pretty close to being inaccurate. And they don't need to prove that the contractor knew what the rule was and intended to violate it. And that's a crucial distinction between the criminal fraud standard, and it's a good notch lower. And when you're looking at significant damages that are being put up by the government through, a course of dealing of maybe many years of submitting these claims, it can really rack up. And they don't have to, like I say, prove you intentionally broke the rule, broke the law. They can prove that you acted either in deliberate indifference or with reckless disregard to a claim's truth or falsity. Well, what the heck does that mean? What it means is that you did not take adequate care to understand whether what you were submitting to the government was true or not. Well, who defines that? Well, when the government puts on the table, $8 or $9 million of potential penalties, plus $2 million worth of damages, tripled, then you get the feeling that, well, they kind of get to decide what that is, because in the face of that, it really is difficult to not come to the table and seek some sort of a negotiated resolution in it. And that's another point. Let's go to the next slide, please, Joey. Because of this leverage, most of these False Claims Act cases, including those with the whistleblower, they tend to get investigated kind of in secret, and that the government finds something, then they result in, I should say, secret to the public. They're secret initially to the target, but very soon the government will call up and say, hey, guess what? We need to have a talk, and I want to interview these 5 to 10 people in your company in 2 weeks or a month or whatever. And they will do those interviews. And then they'll say, well, this is what we found. We think this shows, significant multi-million-dollar False Claims Act liability. Let's talk about what we should do about that. And then there'll be a series of negotiations that goes on. And ultimately, often, because in part due to the significant leverage the government has going into this, there can be the need for a significant financial payment, and also some other penalties too. Disbarment from a federal program. Say defense contracting or participation in the federal healthcare programs, or things like that. I should also note, though, with the Federal False Claims Act, there's a voluntary disclosure program similar to something that Matt mentioned. A lot of times you want to be getting ahead of this, and if you know you have a problem, this is what we're going to talk about significantly on my next slide. Get ahead of it. There's a specific voluntary disclosure program. Go back to that one. I wasn't quite ready for that one yet. Sorry, Jilly, head fake. The voluntary disclosure program, if you're formally admitted into that, if you find an issue in your federal contracting program, you can go to them and say, government, I know about this problem and I'd like to fix it. And in that case, they can't get penalties and they can only get double damages. I will say they have a decent amount of discretion on whether they admit you in the program and how they define double damages. So that's a decision that has to be made very, very carefully after looking at what your particular situation is. Last thing for this slide, and then we'll move on. This is really why I wanted you to come back to this for a second, Joey. Thank you. Is after the federal false claims was enacted, about 6 years ago, the state of Vermont enacted its own state False Claims Act. And that's enforced by our Attorney General's office. And it's very similar in terms of the penalty provisions and the treble damages and the Qui-Tam whistleblower provisions to the Federal False Claims Act. But now you've got sort of a new additional enforcement authority at the state level acting on these potential contract violations. they focus largely on Medicaid fraud and abuse, but not only that. And they're becoming more active, and this is something that Attorney General Donovan is very interested in kind of pursuing. So confronted by all of this, next slide, please. You know, you really want to not shy away from this problem. If you see it in your company, it can be all too easy to sort of say, well, it's complicated. And that really is one of the fundamental problems, is the rules can be incredibly complex, and the factual situations can be very complex, and the rules can change periodically. And you think, oh, how can anybody really adjust things so fast? And that, you know, claim we made 6 months ago, we didn't know about the newest guidance, all that stuff, which is very reasonable, the things you deal with in your company and you need to deal with in your company on a daily basis, you know, that can be met with surprisingly little sympathy by your government enforcement authorities. So, you know, my fundamental point, along with the fact that the False Claims Act gives incredible leverage, is don't ignore a problem. Because if you do ignore it and you wait, and the government finds out about it, and they come knocking on your door, and you don't know that it's even a problem, you could be presented with, you know, an AG subpoena, and they're telling you, we think there's $8 or $9 million of liability or whatever. And you are not ahead of the curve, and you're playing complete catch up, finding out that they've been investigating your company for like a year. And yeah, we returned a subpoena to them with a bunch of documents, but we really didn't give it a lot of thought. You know, that was 2 years ago. What? Really? This is still going on? Yeah, this is still really going on. So my strong advice to you, and I'm not your lawyer, so I'm not giving you your legal advice, but from my experience in this area, is it's really a trap for the unwary to ignore a potential False Claims Act problem in your business. Try not to ignore it, because you lose some opportunities to mitigate the damages. Secondly, it's really, in the process of not ignoring the problem, it's really important for you to learn the facts of that problem. And, you know, Vermont-sized companies oftentimes have really, and for good reasons, really pragmatic approaches. Well, I'm just going to go call the 4 people who are involved in this thing and find out what the heck went on. Then I'll know, and that'll be good. And that's fine at one level, but it also is very risky. If you have counsel come in and do the review, it can be protected by attorney-client privilege and work product. So later on, the government doesn't, if they hit you for a subpoena of all your emails, they don't get the CEO of the company and the project manager emailing back and forth about, you know, a mistake that was made. And you have instead, that is done by counsel. It's protected by our work product doctrine and our attorney-client privilege. And we can either under that cover, so the government doesn't find out about it, Roy, then provide counsel and guidance about how to unwind something if you want to. It's important, I've learned, to do these internal investigations. Jen's going to talk more about this, but to do them in a reasonable scope for the problem and the company. You know, a small company, you can't have a team of 15 lawyers, you know, come airlift it in and line them up and interview everybody. So that's one thing we've really worked hard to do, is learn to be discreet and reasonable in our size and of investigation, and very, very efficient. They can be a really broad investigation. You know, you may have seen the news reporting about an investigation we did to the Department of Corrections, for example. That was a very broad one, or they can be much more narrow and focused and targeted. And so it's important to suss that out as you enter the project with the particular company and the particular problem. But I advocate strongly that we have counsel do this so we can protect it from disclosure later on. Because otherwise, your investigation, which may in a very practical way get to the answer of the problem, you know, you just will potentially serving that answer up on a plate if the government hits you with a subpoena for electronic mail communications or whatever, and it's not done by counsel. Next slide, please. So that's basically, I thought I had one more, I guess I don't. That's basically my 3-minute review of what the risks are and how to mitigate them, and kind of what life is like out there. You know, as I said before, with these big programs coming through and this huge amount of federal funding, I mean, it can be very valuably used, but the government's going to be looking closely.
Okay, thank you. So I'm going to jump in there right where Tris left off. And I want to summarize, I think, some themes that we've been talking about so far, because this will really inform my discussion of what's coming next. So I'm talking about internal investigations. Tim led off with what I think is a huge theme for this topic, which is assess and mitigate. So you want to assess what's going on, assess the risk, learn the facts, and then see if you can mitigate. And that's a real huge overarching goal of this process. I want to talk about, clarify what I'm discussing. I'm not talking specifically about the government's investigation that Tris referenced before. My specific conversation has to do with the company's investigation, and in particular, what the attorney's role is in that. Because again, as Tris said, you don't want to provide the roadmap for either the government's case or in the context of a private litigation in which internal investigations can also play a role, the other side's case. So the purpose of the investigation, who performs that, is all really critical. As Tris said, there is no one size fits all to this approach. It's a case by case. So I'm going to cover some common circumstances of when you might see an internal investigation initiated, what that scope is, when you might want the independent investigation with a report and recommendations at the conclusion, and how that purpose will impact whether the privilege applies or not. And then to sum up, what does it look like to execute on one? Common circumstances in which an internal investigation comes into play. Tris's conversation really sets the groundwork for that. False Claims Act situation, again, the organization receives a subpoena or a notice of noncompliance. You want an attorney to get in there right away, figure out what's going on, and assess the facts. And I am not speaking about jumping in with both feet first. As I'll get to when talking about what the independent investigation looks like, you're going to want a carefully crafted scope of the investigation and a plan to evaluate all of the information up front. And you want to have that even in a small independent investigation, so you know what's going on and so that you can keep control. And I say you, what I'm talking about here is making sure the attorney is keeping control of the investigation. Internal investigations at a really high level come into play whenever a company has an issue that it needs or wants to figure out. This can come from some complaint, allegation of misconduct, fraud, abuse, harassment in the workplace or organization. It can come from a suspicion, or it can arise from a suspicion. So rather than waiting for an allegation to surface, your organization requests that an internal investigation is conducted so that you can get out ahead of the situation. This is the assessment that leads to potential for mitigation. An allegation can come from an internal source. Tris mentioned the whistleblower situation where an employee comes forward to report that an organization has engaged in an activity that is illegal. In that case, suit may or may not have been filed, at that time. But again, having counsel come in to do the investigation can be critical. It can also come from a routine audit. This can be a financial audit that may have identified some concerning factual circumstances, and it may be a small point, but it could also be a tip of the iceberg. You want to get a handle on what's going on, figure out where the issues are, if they are more prevalent than what's been identified by the audit, and then try to get ahead of it. It can also arise from a third-party allegation. So examples may include regulatory compliance or environmental compliance. I can think of a situation where your organization may receive an allegation that with respect to performance as it pertains to a specific third-party entity, but because of the nature of this performance, the same scope of work or advice was provided to several other parties, and your organization wants to know whether there was incorrect advice in all circumstances, or just some, or just the instance that has been brought to your attention. So based on this, you're going to want to evaluate, have the attorney evaluate the exposure in those circumstances, and then again, you'll have the possibility of taking steps to mitigate rather than waiting for other situations to come forward. So what's the scope? Again, not a one size fits all. This is going to be a case by case situation. It's going to be critical in all instances to gather facts quickly and efficiently, and then, if possible, look for ways to mitigate. Timing, and this is not a surprise, is always critical in preserving facts. Information may not be fresh in people's minds for long, and so you want to make sure that and when I say you, the attorney wants to make sure that the information is fresh when gathered. Preservation of information is also going to be a critical component. So this involves steps such as making sure notices of preservation go out quickly, and that many companies have document preservation and destruction policies. And preserving that information and making sure that there is a halt on the information that may be helpful to the company will go out in a notice as soon as possible. Key to all of this is preservation of attorney-client privilege. So as many people may know, but it bears repeating, the legal privilege has boundaries. Whether it applies in any given circumstances has to do with the purpose of the investigation. So very, very generally, whether the legal privilege applies in an investigation, the primary purpose has to be to give legal advice. So an example may be that the organization is notified of serious misconduct with which they could face legal repercussions. They retain a lawyer to investigate and conduct the investigation and to advise the organization based on the investigation. That would trigger the all-important legal privilege. This may not be as clear when there's a situation where a company policy requires that an investigation be conducted in a certain situations. So again, it can be case by case, and it should be evaluated immediately for the purpose of preserving the ability to invoke that privilege. Benefits and risks, Tim discussed, Tim and Trist have both discussed this. You know, again, the risk of jumping in with 2 feet first before retaining counsel, talking to them about the scopes, is that you create that roadmap and that email trail that is not helpful and may prove the case. So evaluating what that scope is, what the investigation will look like, having a discussion about what the purpose is, whether the legal privilege can be invoked, is going to be really critical. The benefits of doing this quickly and efficiently are you preserve the facts, you evaluate, and then again, you know, not to harp on this, you look for ways to mitigate. There is also, and Tris alluded to this in his discussion, but there are situations when an investigation is what we will also call an independent investigation. This can be initiated by an organization, it can be initiated by an educational institution or a government agency who wants an investigation of the organization's policies, procedures, actions, and then wants a report to come out that has fact-finding, conclusions, and then recommendations about policies and procedures to improve the conduct and operating procedure going forward. Again, these are situations where you might hear of the calls for transparency. These are certain circumstances where the independent investigation may not have the privilege attached to that for good reason. There is still value in having lawyers conducted even when you may not be seeking to have the privilege attached, because of the fact-finding expertise and the protocol that you put in place in a situation where you would have that privilege attached can be easily applied to the independent investigation format, which is slightly different than maybe an internal investigation where you are doing it for the purpose of providing legal advice. So again, the value of having the experienced and credible fact-finding followed by reliable conclusions and recommendations that can be tested against evidence gathered in the investigation can be invaluable. So next I'm going to talk about, so what happens after the decision is made to conduct the internal investigation. So you're going to have a detailed scope of what that looks like. And again, this can be, there's not one size fits all. It can be quick, and it may not involve many witnesses. It really depends on what the issues are. We'll have a written protocol to follow. It'll be documented. So we want to have those sort of documents in place that the entire team can follow the protocol to keep this investigation moving and consistent throughout. There's going to be a period where the witnesses are identified, interviewed. Steps are going to be taken to preserve documents. There may be interviews that are for a preliminary purpose to identify what documents there are, where are documents kept. We think of electronic documents, but even nowadays, that's not all that exists. So there would be a period of meeting with people, understanding how and where they keep the information that is invaluable and relevant to the investigation. In most contexts, again, if we're talking about the internal investigation process, it would be absolutely imperative the witness is informed that the attorney represents the company. The employee who is being interviewed will be told that they are not the client. It's clear, it's made clear that the privilege belongs to the company. The privilege is controlled by the company. That's going to be a critical piece of any interview with an employee. So summing up, we've talked about really, the most obvious examples: when you get a subpoena, when you get a request for an investigation, when you get any sort of information that would trigger a concern that there is misconduct in the organization, there's an allegation of wrongdoing. Again, not a one-size-fits-all situation. You're going to evaluate the specific situation, evaluate the privilege and purpose of the investigation. And again, this will all depend on these specific issues: identification of the categories of documents, witnesses, and legal issues, and then consider mitigation measures. I'm going to turn it over now to Jolie to lead us through any questions that people may have. I saw one pop up from, I believe, Joe Choquette. So Jolie, I'll let you take it from here.
Yeah, so we did have one question come in. Does the whistleblower earn a financial reward for a successful claim other than just recuperating attorney fees?
Yeah, that was an important omission from my PowerPoint. The whistleblower, known as a relator under the False Claims Act, can earn an award of 15 to 25% of the recovery if the government joins in the suit, and a bit higher if the suit goes on without the government. We had a case where the government settled for $155 million in a healthcare fraud case, and the relator walked away with something in the order of $30 million from that. Which I say that just because it's interesting. One, two, for good, strong False Claims Act cases brought by credible relators, the government is willing to give us handsome benefit for someone who recovers such a large amount of the public fisc. And then the third point that I would make is, with that amount of money potentially out there, you do get some kind of squirrely sorts of relators and whistleblowers sometimes. And so, one of the things that we've learned from our practice is sort of trying to separate the wheat from the chaff and deal with very credible, strong relators and not bring weak cases. Anyway, Jen, Tim, and Matt, other thoughts on that?
No, I think that's right, Tris, and it highlights for me, one of the themes of our talk so far has been this notion of, getting on top of things early, getting your arms around things early with the advice of counsel. It can be invaluable. I know from my time in the government, when I sat down with executives, because the actions of their company were under investigation, it was always valuable to me and impressive to me and to the Department of Justice if they had taken prophylactic steps to address a problem or assess whether there was a problem with credible attorneys before the government got directly involved. I think the same theme goes with potential whistleblower cases, given the financial incentives that are out there.
Jen, I had a question for you based on, if I can, can you talk about how you kind of the nuts and bolts of how this internal investigation thing is done? I mean, how do you talk to the people? Do you separate them out? Do you bring them into the secret star chamber? How does that work?
Yeah, so that's once you've identified the witnesses, you will talk to them. And so that was when I was going through, it's going to be critical. So if we're talking about an internal investigation, the purpose of which we've identified is to give legal advice to the company, then you'll give that what we know of as the Upjohn warning effectively, which is exactly what I was talking about before. You let the witnesses know, if they're employees of the company, that we are the attorneys for the company itself, not the employees, and that the privilege belongs to the company. The company may decide to waive the privilege as it goes forward, but that's the company's decision to make. And so you speak with them. In our practice, we have carefully crafted outlines, and we have thought of the questions. This is not a shoot from the hip situation. You want to make sure that you are being really specific about what you want to ask the folks, giving considerations to kind of the whole investigation, and then based on each witness interview, reevaluating whether there are additional witnesses to interview, and then the next step. And then, each conclusion and evaluation is going to be supported by the facts that are identified throughout. So identification of documents is going to be really critical. So going into the witness interviews, if there are documents that will be helpful in that interview, that will maybe help in identifying or learning new information, you want to make sure to have that in advance. So there's going to be consideration given to whether or when the witness interview piece starts, and that's not going to be consistent throughout, but generally you're going to want to have a really good understanding of what the documentary evidence is first, and then start to get to work on the witness interviews.
That's helpful. And Tim, your experience prompted me to think about your take on what is one of the key crucial decisions. Let's say you've got a company and they find they've got a problem. Talk to our audience about how you, from your experience being on the enforcement side, kind of can guide somebody on the things that the government's going to consider if you do sort of fess up or try and fess up in a controlled way, or try and work through that decision about whether to come forward. Kind of what are the benefits that one can reasonably think the government might provide for coming forward? Thanks.
Well, it all, as we always say as lawyers, it all depends on the circumstances. But, in broad brushstrokes, once a team of internal investigators or a single internal investigator follows the process that Jen has outlined, review of the pertinent documents and communications, interviews of the key people that are then memorialized in, depending on the circumstances, privileged memoranda that can then be preserved, and then possibly the completion of a internal investigative report that sums up for the key decision makers within the company whether there's a problem, the extent of the problem, what the parameters of that problem look like, and the sort of risk level. That document and can also include, remediation suggestions, and the company can take remediation steps. And this is we have seen this in our private practice here since we left the government, is those recommendations from a credible source on remediation steps. If that process is played out in that way, and then you receive a subpoena by the U.S. Attorney's Office or by the Attorney General's Office, or a request for interview, you can make an informed decision. This is how risky we think, this is how much risk we're at for civil enforcement of a particular kind or criminal enforcement of a particular kind. Does it make sense, knowing the players, knowing the kinds of things that they look for, to bring to them what we've done and say to them, given the limited resources of the government, given the number of problems that the government has to examine every day, is this one that the government needs to spend its precious resources on? Or you as a federal prosecutor, or as a state assistant attorney general, need to spend your precious resources on? Or is this something that has been solved in a competent, ethical, rigorous way, such that valuable taxpayer money doesn't need to be spent digging through this again? It's going to be a judgment call. It is not, Tris, and I think this is the point we've been making, it is not a call you ever get to make if you try and whistle by the graveyard. And I think that's really a take-home message for us as we wind this down on what is now not a snowy afternoon, a sunny afternoon. You know, to the extent that sort of whistling past the graveyard and crossing your fingers and hoping for your best was ever a good strategy, in the current environment, it is not a good strategy. We are seeing clear, and other experts are seeing clear and distinct signs of a very, very, very intensely reinvigorated approach coming out of the United States Department of Justice, and in terms of investigating and digging into these matters. It's not just something that's happening way away in DC. It's here in Vermont. It will continue to be here in Vermont. So if there's something keeping you up at night, you should look into it as a business leader, would be my sort of final take on these things. I don't see, Jolie, that we have any other questions. Does anyone else have questions for us? Seeing none. Seeing none, thank you everyone for being here. Much appreciated.